purchase contract. For those of you in the Tuesday night class, we have a good purchase contract within the textbook. There's not a good purchase contract in this textbook. I will bring some blank purchase contracts with me next week. But those of you in Tuesday night class, I'll bring enough for the whole class. If you don't want them, it's fine, but I'll make some copies. It's a Board of Realtors general purchase contract. The reason I like Board of Realtors contract, it's been tried and true. It's been fought on all kinds of sides, and they've come up with the best solution for a general contract. When he was talking last night, our speaker, part of this whole thing about .loop is when you sign up and use it, they bring these contracts through. Well, a lot of the realty companies get their contracts from the Board of Realtors, and they just put their logos on the Board of Realtor contract. So lots of companies use the same exact contract through Cincinnati. Where we don't use the same exact contract is when we do commercial. Commercial is each depending on what attorney we get, they typically want to do their own thing. And they're not on a .loop. They're not sharing information. They're not at all doing that stuff because it's commercial and you're paying a lot of money. But for the residential, we have a standard contract that's acceptable in our market here in Cincinnati. So the real estate contract, it's an agreement whereby a seller promises to sell an interest in realty by conveying a deed to the designated estate for which the buyer promises to pay a specified purchase price. So they're conveying a deed. The deed is what is conveying title in residential real estate. The statute of frauds necessitates that certain contracts to be enforceable must be supported by written memorandum signed by the party against whom enforcement is sought. In the state of Ohio, anytime you're dealing in real estate, if it's purchasing real estate, it has to be in writing. If it's leasing real estate for a year or longer, it has to be in writing. That's Ohio law. Most states have similar laws. A memorandum is writing that contains essential terms and a satisfaction of statute of frauds. Memorandum ordinarily contains the names of the party, description of property, purchase price, other essential terms, conditions, signature of the party against whom the enforcement is sought. We do lease memorandums. If you're a long-term tenant, you're putting a lot of money into your premises, you want to do a lease memorandum. It's a few pages. It simply says you have a lease that starts here and here. You don't have to put all the economics of the lease, but you've got a lease that starts and ends here. You have the right to occupy that. You want to file that in the courthouse where the property is because you want that to be part of the record. So if anybody's ever investigating title on the property, you're showing the world that you have a leasehold right to be there. So memorandum is a short and condensed version of the contract that we can record and give the world notice that we have rights. That's why we do a memorandum if we're not going to do a full contract, where we want to be able to give something to be recorded. Part performance, exception to compliance with the statute of frauds. Various views as to what constitutes an act of past performance sufficient to remove a contract from statute of frauds. So, man, I've been trying to buy this place for years, but it's real estate. Ohio says real estate has to be in writing. What they're saying is some of this part performance kind of stuff might say that the statute of frauds, you don't have to put it all in writing. Real estate isn't one of those things. It might be for some other piece of something that you're trying to buy. Parole evidence, rule, oral or other evidence extraneous to the written instrument. We hear parole evidence when we talk about people going to court, where they're going to give additional evidence. Broker has authority to use pre-printed contract forms. As a licensed real estate broker, I am not allowed to write contract law. I can use pre-printed forms. I can fill in all the blanks I want, but I'm not allowed to write contracts. But that's why I have the Board of Realtor contracts. I can use them. I can fill in the blanks. So I was talking to you about today. I'm writing a contract for this roof. But it's a contract that's already been prepared. I'm filling in blanks. I'm not going through all the legal stuff. Provisions of the real estate purchase contract. Obviously, it's a date. It needs to be dated. The parties, the property description. For real estate contract, the address is property description enough. We don't do a whole legal description the way you will with a deed. The price should be in there. Contingency clauses. Provision within a contract makes performance under the contract conditional on the occurrence of a stated event. What are standard conditional contingencies that we would have in our marketplace. What? Appraisal value, selling another home, passing the inspection, qualifying for financing. Okay? Lots of little things can come into that. Depending on how creative your agent is, they can write a lot of different things in contingency provision. But we have standard ones that we do in our marketplace. The possession, the date the seller is required to surrender possession. So when are they going to give up the keys to the house? In our market, giving somebody the keys is when we typically think they're getting possession. It's just customary, common law, old-fashioned kind of a thing. Give them the keys, you're giving them possession. That doesn't mean I'm not going to rekey the locks the day I get it, but I've given you keys to get in. Evidence of title, a document such as title insurance, which verifies ownership of property. Somewhere in the real estate contract, it's going to be able to say that this person has to give me a deed. They have to prove they have the right to that they have the right to transfer this property. The form of deed. Okay, so how many different forms of deeds? We have the general warranty deed. We have special warranty. We have limited warranty. We have quitclaim. We have different types of deeds for whatever it is we're dealing with. The property inspection. The home warranty plan. Whether you buy one or not, contracts have a little thing in them about a home warranty plan. Earnest money. Something about how much earnest money. It's blank. You're going to fill it in. Where the earnest money is going to be held. It's very specific in the contract that the earnest money will be credited toward the purchase price. Signing. Obviously, this contract has to be signed by all parties. All parties. Husband and wife. If they're not divorced, but they might be separated, still has to be signed by husband and wife or the married partners, even if they're in the middle of a divorce. If there's no divorce decree, partners have to sign. Attestation acknowledgement. What?
Wait. So if you're married and your wife comes, you both have to sign the contract.
You should, absolutely.
Should or you have to?
Well, more the selling piece. You're not divorced yet. Both parties have to sign.
Okay. I was thinking purchasing.
No, purchasing is not quite the same, but selling, absolutely both parties.
And when you're renting as well, right? If you're renting your property, someone, both the husband and the wife.
If the landlord, husband and wife should be signing, yes, they should both sign. Unless it's held in a partnership. But if they are the two deed holders, they should both be signing because they're giving up rights. And that's why you're asking for the husband and wife to acknowledge, again, or the partners to acknowledge. Even if they're not, they're getting ready to be separated. They both are giving up rights. They both still have rights until they have a divorce decree.
If they're both on the deed, though.
No.
One of them is on
Married. If they're married in Ohio, there's dower rights.
So if you're renting a property and only one of the
Landlords, not
Landlords,
tenant, right?
even if that property is not in the
Typically, you're going to only get one name. It's better to try to get both, but typically in a rental agreement, it's not quite as strong as a sale agreement, but you would like to get both. You're going to ask your landlord, how's the title held? What is it, a partnership? You want to see who's allowed to sign my lease. Most people can't even think about getting that technical. They don't. They just say, okay, the landlord signed the lease. I don't know who the landlord is. I don't ever want to see him. I just want him to fix stuff when it needs to be done, and I pay my rent. It's always would be great to get both, but in the sale it has to be both. The lease it does not have to be both. Attestation and acknowledgement, that's where the notary is signing it. And in Ohio, a lawyer can attest to leases as well. You don't have to have a notary if you've got a lawyer there. Closing, seller assist. What's going to happen with the prorations? How will costs be figured at the closing? These are all things that are part of that real estate contract. More than you realize. And that is it. We are done. Okay, any questions?